A warm welcome to one and all to the 18th P.G.C. CHENGAPPA Memorial Lecture. May I request the President of Lahari Advocates Forum, H.J. Sangvi, to escort Honorable Chief Justice, Justice Vibhu Bhakru onto the dais. May I request the Secretary, Ms. Sumana Baliga, to escort Honorable Justice Suraj Govindraj, Judge Karnataka High Court, to the dais. It is said in the ancient texts, Nahi jnanena sadrisham, meaning there is nothing so purifying as knowledge. It has been a constant endeavor of Lahari Advocates Forum in its 40th year this year to improve the knowledge base of its members through various programs, seminars, study circle meetings. The P.G.C. Memorial Endowment is one such stellar example of the spirit and values of the Lahari movement. And the memorial lecture held annually is an integral part of the endowment. Here's a warm welcome to one and all to the P.G.C. CHENGAPPA Memorial Lecture on the challenges in the investigation and prosecution of cybercrimes.
जय भारत जननीय तनुजाते, जय हे कर्नाटक माते, जय सुंदर नदी वनಗಳ ನಾಡೆ, जय हे रस ಋಷಿಗಳ ಬೀಡೆ. ಭೂದೇವಿಯ ಮಕುಟದ ನವಮಣಿಯೇ, ಗಂಧದ ಚಂದದ ಹೊನ್ನಿನ ಗಣಿಯೇ, ರಾಘವ ಮಧುಸೂದನರವತರಿಸಿದ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ. ಜನನಿಯ ಜೋಗುಳ ವೇದದ ಘೋಷ, ಜನನಿಗೆ ಜೀವವು ನಿನ್ನಾವೇಶ. ಹಸುರಿನ ಗಿರಿಗಳ ಸಾಲೆ, ನಿನ್ನಯ ಕೊರಳಿನ ಮಾಲೆ. ಕಪಿಲ ಪತಂಜಲ ಗೌತಮ ಜಿನನುತ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ. ಶಂಕರರ ಮನುಜ ವಿದ್ಯಾರಣ್ಯ, ಬಸವೇಶ್ವರ ಮಧ್ವರ ದಿವ್ಯಾರಣ್ಯ. ರನ್ನ ಷಡಕ್ಷರಿ ಪೊನ್ನ, ಪಂಪಲ ಕುಮಿಪತಿ ಜನ್ನ. ಕುಮಾರ ವ್ಯಾಸನ ಮಂಗಳಧಾಮ, ಕವಿ ಕೋಗಿಲೆಗಳ ಪುಣ್ಯಾರಾಮ. ನಾನಕ ರಾಮಾನಂದ ಕಬೀರರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ. ತೈಲಪ ಹೊಯ್ಸಳರಾಳಿದ ನಾಡೆ, ಡಂಕಣ ಜಕಣರ ನೆಚ್ಚಿನ ಬೀಡೆ. ಕೃಷ್ಣ ಶರಾವತಿ ತುಂಗ, ಕಾವೇರಿಯವರ ರಂಗ. ಚೈತನ್ಯ ಪರಮಹಂಸ ವಿವೇಕರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ. ಸರ್ವ ಜನಾಂಗದ ಶಾಂತಿಯ ತೋಟ, ರಸಿಕರ ಕಂಗಳ ಸೆಳೆಯುವ ನೋಟ. ಹಿಂದೂ ಕ್ರೈಸ್ತ ಮುಸಲ್ಮಾನ, ಪಾರಸಿಕ ಜೈನರುದ್ಯಾನ. ಜನಕನ ಹೋಲುವ ದೊರೆಗಳ ಧಾಮ, ಕಾಯಕ ವೈಣಿಕರಾರಾಮ. ಕನ್ನಡ ನುಡಿ ಕುಣಿದಾಡುವ ದೇಹ, ಕನ್ನಡ ತಾಯಿಯ ಮಕ್ಕಳ ದೇಹ. ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ. ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ, ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ. ಧನ್ಯವಾದಗಳು.
Thank you, Ms. Lakshmi, for the sincere and evocative rendition of the Nada Gite, which has set a harmonious and an uplifting tone to our gathering here. What started as a small study circle discussion in 1984-85 amongst a few advocates, including the late Mr. P.G.C. CHENGAPPA, has now transformed into a socio-cultural educative organization, with many initiatives floating on its waves, thereby symbolizing a wave of ideas. The P.G.C. CHENGAPPA Memorial Lecture is more than a tribute to late Mr. P.G.C. CHENGAPPA, and it is a continuation of ideas, selfless work, and reaffirming the values that the late Sri P.G.C. CHENGAPPA represented. I now invite the President of Lahari Advocates Forum, Sri H.J. Sangvi, to deliver the welcome address.
Honorable Chief Justice Vibhu Bakro, Honorable Justice Suraj Govindarajan, esteemed member of the bench and bar, respected seniors, dear colleagues, students, and distinguished guests, a very good evening to all of you. It is my honor and privilege on behalf of the Lahari Advocates Forum to welcome you all to the 18th P.G.C. CHENGAPPA Memorial Lecture. The annual gathering is a moment of reflection and tribute dedicated to the memory of a man whose integrity, discipline, devotion, and commitment to the profession continue to guide us. Late Sri P.G.C. CHENGAPPA, more than 3 decades ago, under his vision and leadership, a small group of like-minded advocates like our Surya Narayan Rao many advocates, then they came together to form a study circle. I was young in the bar. What began as a simple initiative to discuss law and exchange knowledge gradually grew into a vibrant organization, and today it stands before you as Lahari Advocate Forum. At its heart, Lahari has always stood for one principle: of the advocates, for the advocates, and by the advocates. Over the year, Lahari has evaluated into a platform that nurtures not just legal knowledge, but to overall growth of the legal fraternity. Through the Lahari Law Academy, we continue to support young advocates and law students with moot courts, parliamentary debates, talent search competitions, workshops, and seminars. Our weekly study circle, Chintana Mantana, it has held every Thursday, has become a space for thoughtful engagement with law procedure and emerging issues. We have nurtured a book bank stocked with writing and eminent jurists and thinkers, encouraging our members to cultivate reading habits essentially to our profession. Along with academic initiatives, Lahari has always believed in contributing to the society through blood donation camps, cultural programs, painting competitions for children, and other community-oriented events. For over 30 years, our in-house publications, we were publishing magazine by name as Communic, and our Surya Narayan Rao, the main editor who is present here, has chronicled these activities and kept the bar connected and informed. Now the entire system has changed now. The P.G.C. CHENGAPPA Memorial Lecture, instituted in 2007, after his ultimately demise, remain one of our most meaningful traditions. Each year, eminent jurists and scholars have graced these platforms to speak on issues of contemporary importance, enriching our understanding and strengthening our collective commitment to justice. Today, we continue that legacy with the 18th editions of the lecture, and we are deeply honored to have Honorable Justice Suraj Govindarajan with us to deliver an address on a subject that sits at the heart of motion, legal discourse, challenge in the investigation and prosecution of cyber crimes in the era of digital evidence and artificial intelligence. At a time when technology influences every aspect of life, including crime evidence and even the administration of justice, this topic could not have more relevant as lawyers, investigations, and judges grapple with the complexities of digital cross-border offenses, unsecreted data, and rapidly evolving AI systems, guiding and clarity become essential. We look forward to Justice Suraj Govindra's insights on these challenges and the way forward. We are equally honored by the presence of our guest of honors, Honorable Chief Justice Vibhu Bakro. Sir, your gracious presence strengthens our commitment to academic engagement and inspires members of the bar to uphold the highest standard of professionalism and ethics. We deeply appreciate your encouragement and guidance. Thank you, sir. Events like this are possible because of dedicated efforts of countless individuals. I extend my sincere gratitude to the members of Lahari Advocates Firms, the organizing committee, our seniors, our young advocates, and our well-wishers who have worked tirelessly to make this evening possible. Their commitment reflects the same spirit with which Sri CHENGAPPA built the earliest foundation of this firm. As we gather today to celebrate his legacy, let us also remind ourselves that the true homage to Sri P.G.C. CHENGAPPA lies not only in remembering him once a year, out in living and the values he embodied: discipline, humility, scholarship, dedication, devotion, collegiality, and service to the legal community and to the society. Let us take forward his vision by continuing to support one another, by engaging in other meaningful learning, and by upholding the dignity of our noble profession. Thank you all for joining us this evening and for being a part of these traditions. I wish you all enriching and inspiring session ahead. Jai Hind.
Thank you, sir, for taking us through the Lahari movement and also extending a warm and gracious reception for all the dignitaries on the dais and off the dais. As a token of our sincere gratitude for having graced us with your presence, with your august presence, I request the Vice President of Lahari Advocates Forum, Shri Sanna Naik sir, to gift the guest of honor, Honorable Chief Justice Mr. Vibhu Bakro, a sapling, which is a symbol of nature and growth. I now request Mr. Vishwanath Reddy to present Honorable Justice Suraj Govindraj with a sapling as a token of our gratitude for having agreed to deliver the 18th P.G.C. CHENGAPPA Memorial Lecture. We welcome one of our founding members of the Lahari Advocates Forum, Shri Suryanarayan Rao. I request Srinivas Reddy to present Suryanarayan Rao with the sapling. Thank you, sir, for your continued encouragement and support. Mrs. Sushila CHENGAPPA, always smiling and welcoming, and your continued support to all the efforts of Lahari Advocates Forum. Welcome, ma'am. And I request Madhavi to gift you a sapling so that you can put it in your beautiful garden and for you to remember 18th P.G.C. CHENGAPPA Memorial Lecture. Cardinal John Henry Newman's famous hymn goes, and I quote, "Lead kindly light amid the encircling gloom, lead thou me on." Beautifully translated into Kannada by the renowned Kannada literary figure B.M. Shrikantaya, "Karunalu ba bedake, musukidi mabbinali, kai hididu nadesennenu." I now invite the dignitaries on the stage, on the dais, to light the lamp, symbolizing triumph of light over darkness, knowledge over ignorance, and ushering in wisdom and positivity, a cherished Indian tradition. I also request the executive committee members to join in. Our Chief Justice lights up the whole environment. Thank you, sir, for lighting up the program and setting a positive tone to it. I now request Mr. Harun Rashid to introduce the guest of honor of the day, Honorable Chief Justice, High Court of Karnataka, Justice Vibhu Bhakru.
Honorable Mr. Justice Vibhu Bhakru was born in Nagpur in 1966. He did his schooling from Delhi Public School, Mathura Road, New Delhi. After completing his schooling, he enrolled as a student with the Institute of Chartered Accountants of India and commenced his articles with Thakur, Vaidyanath, Iyer and Co. on 21st March 1985. He graduated from Delhi University in 1987. After completing the course of BCom Honours, he cleared his final examination for Chartered Accountancy from the Institute of Chartered Accountants of India in 1989. He received his LLB degree in 1990 and enrolled as an advocate with the Bar Council of Delhi in September 1990. He practiced in the Supreme Court, High Court of Delhi, Company Law Board, and various other tribunals. He was designated as Senior Advocate by High Court of Delhi on 28 July 2011. He was appointed as Additional Judge of High Court of Delhi on April 17, 2013, and as Permanent Judge on March 18, 2015. Appointed as Acting Chief Justice of Delhi High Court with enforce from 5th December 2024 to 21st Jan 2025. And now presently appointed and took oath as the Chief Justice of Karnataka High Court on 19/7/2025, 19 July 2025. His Lordship's notable judicial work in arbitration and ADR recently emphasized the need to improve the quality of arbitral awards in Bangalore ADR Week 2025, suggesting boards to draft review awards for consistency and efficiency, data privacy and technology. As Chief Justice presided over the PhonePe versus State of Karnataka case, where the court examined police powers to demand user transaction data under Section 91 CRPC. His bench balanced privacy rights with investigative needs. Corporate and commercial law, His Lordship known for his rulings that strengthen institutional accountability and uphold statutory protections for intermediaries. His Lordship is recognized for his sharp commercial law insights and progressive arbitration jurisprudence, advocates for institutional reforms in arbitration to enhance India's global credibility, seen as a bridge between corporate law practice and judicial innovation, bringing practical business sensibilities into judicial reasoning. We welcome Your Lordship, Honorable Chief Justice, Mr. Vibhu Bhakru. Thank you.
Thank you, Mr. Harun Rashid. I now request our guest of honor, Honorable Chief Justice of Karnataka High Court, Justice Vibhu Bhakru, to address the gathering.
Justice Suraj Govindraj, my brother, my sister and brother judges present here, Mr. H.J. Sanghvi, President, Srimati Sumana Baliga, Secretary and other office bearers of the Lahari Advocates Forum, Mr. Bharat Kumar, Registrar General and other registrars of the High Court. Ladies and gentlemen, good evening to all of you. It gives me great pleasure to join you all today for the 18th P.G.C. CHENGAPPA Memorial Lecture. I'm honored to be here and I thank Lahari Advocates Forum for the invite. Let me begin by acknowledging the remarkable work done by the Lahari Advocates Forum for nearly 4 decades. Lahari Advocates Forum has been much more than an organization. It's been a movement You have nurtured young talent, encouraged cultural and literary pursuits, supported advocates in need, and created platforms for continuous learning. Maintaining such enthusiasm and commitment over so many years is no small achievement. The fact that this lecture series has continued uninterrupted for 18 years speaks volumes about your dedication. Today we also gather to remember Mr. P.G.C. CHENGAPPA, a name that continues to evoke respect and affection in the Bangalore bar. Although I never had the privilege of meeting him, everything I've read and everything that I have heard paints a picture of an extraordinary human being. He was a lawyer of immense ability, an excellent teacher, a gifted organizer, and above all, a person with a large heart. His students remember him with great fondness. His colleagues admired his discipline and sincerity, and the bar valued his leadership. What is most striking is his humility. He believed that whatever he did was simply a part of his duty, not something that required any applause. In today's world, this is a rare quality. The Lahari Advocates Forum deserves special appreciation for keeping his memory alive year after year, reminding us of what the legal profession should stand for: integrity, service, and dedication. Let me now turn to the topic of this afternoon's lecture, challenging in the investigation and prosecution of cybercrimes in an era of digital evidence and artificial intelligence. This is a subject that touches every one of us, both as citizens and as members of the legal fraternity. We are living in times where technology is advancing faster than our ability to regulate it. Cybercrimes today are far more sophisticated than anything we've imagined even a decade ago. Offenses can be committed anonymously from any corner of the world and often leave behind little or no physical trace. The rise of artificial intelligence has added a new layer of complexity, whether it is in the form of deepfakes, identity manipulation, or automated attacks that operate without direct human control. For judges and advocates, this presents several challenges. First, digital evidence is inherently fragile and technical. We now hear terms such as hash values, metadata, encryption, algorithms concepts that were once confined to computer science textbooks. Today they have entered our courtrooms. To understand and appreciate such evidence, we need to update our own knowledge constantly. Second, the investigative machinery is struggling to keep pace with this volume and the sophistication of cybercrimes. We need more trained investigators, more forensic labs, and quicker access to technical expertise. If investigations are delayed, crucial digital trails may disappear forever. Third, the jurisdiction becomes a major hurdle. Many offenses originate outside India. Securing cooperation from foreign agencies takes time, and offenders exploit this delay. Fourth, the spread of deepfakes has created a new kind of harm, where a person's very identity can be misused or manipulated. Courts are being called upon to protect personality rights, to issue rapid injunctions, and to deal with entirely new forms of digital injury. These challenges demand that both the bench and the bar adapt. Our younger lawyers especially have a tremendous opportunity before them. Cyber law and digital evidence are emerging fields. Those who equip themselves with technical knowledge will not only enrich their practice, but also play a vital role in shaping the legal response to technology-driven offenses. I must take a moment here to appreciate my brother, Justice Suraj Govindraj. Choosing such a contemporary and challenging topic reflects his keen awareness of the rapidly evolving legal landscape. I am certain his lecture will shed valuable light on many of these issues. I once again congratulate Lahari Advocates Forum for their continued commitment to the legal community. Thank you. Jai Hind.
Thank you, sir, for your enriching overview, a kind of warm-up to the audience on the topic. I now request Madhavi to introduce Honorable Justice Suraj Govindraj.
Honorable Mr. Justice Suraj Govindraj. His Lordship was appointed as a permanent judge of Karnataka High Court on March 1, 2021. He was initially appointed as an additional judge on September 23, 2019. His Lordship born on May 14, 1973. He graduated with an LLB from the prestigious National Law School of Indian University. He enrolled as an advocate on June 23, 1995, and practiced actively in wide range of legal fields, including civil, commercial litigation, contracts, property law, arbitration, company law, intellectual property rights, and constitutional law. His Lordship is known for providing a patient hearing to all the parties and actively encouraging junior lawyers to argue their matters. His Lordship is involved in legal education and has been invited to speak at National Judicial Academy in Bhopal and various colleges. He is also a member of several committees, including the Mediation Committee. His Lordship has provided over several significant cases, including those related to environmental law, Real Estate Regulation and Development Act, KCA election case, and IPC 498 applying in live-in relationship case, and other administrative matters. I conclude by saying that His Lordship is known for clarity in procedural rulings and progressive interpretation of family and criminal law, actively involved in cases balancing individual rights with institutional accountability. His judgments often emphasize fairness, transparency, and adherence to constitutional principle. Thank you.
Thank you, Madhavi. I now request Honorable Justice Suraj Govindraj to deliver the 18th P.G.C. CHENGAPPA Memorial Lecture. Over to you, sir.
Good evening, everybody. Thank you, Madhavi, for speaking so much about me. I don't think I'm worth that much of what you spoke. Justice Shri Vibhu Bakru, Chief Justice, State High Court of Karnataka, my brother judges, Senior Counsel, Ms. Sushila Chengappa, Mr. Suryanarayan Rao, my members of the bar, more importantly, the students of law, the future of tomorrow, the leaders of tomorrow. The interaction that I've had with Ms. Chengappa and Mr. Suryanarayan Rao, I don't know whether they would remember, was in the civil court when they used to be distributing communique, and they would have the Lahari badge on the thing, and we would ask them, can we also have the badge? And I think I'd been given one badge, which must be there somewhere, but I don't know where it is. So sorry, sir, but that is the interaction that were there. Then, of course, Prashant, so many people got involved with Lahari, and it was, for us youngsters, it was a good forum where we could read something. Today, at least, we have so many other fora, so many magazines where we can refer to. Mr. Egde is here, so many things are available today. But during those times, it was communique which gave the gist of things for us to look at as young lawyers who could not afford to buy many of those things which were available. We gather here today not merely to discuss the future of law, but to honor a man who was in many ways its finest custodians, as has been spared. See, Pulyanda Ganapati Caesar Ganapati, affectionately known as P.G.C. and Caesar, what a name to have as Caesar, Ave Caesar, was a colossus who walked his corridors with a dignity that inspired generations. His leadership did indeed set him apart, as was mentioned. In 1973, the year that I was born, he was the General Secretary of the Bangalore Bar Association. He orchestrated a moment of legal history, an endowment lecture by the legendary Mr. Nani Palkiwala, where 10,000 people attended. It is not that 10,000 people would attend Mr. Nani Palkiwala's lecture, but to organize such a function, to be that logistician and to be able to do it is something amazing. To organize this function, the organizers must have taken so much trouble. Imagine it is 10,000 people. Mr. CHENGAPPA believed that the law must serve the living. His seminar he conducted on Karnataka Land Reforms Act in 1973 was supposed to be so impactful that the state government was compelled to incorporate its findings into the amendments in the act in 1973. Such an impact, to have one seminar and to impact amendments into an act, is something unheard of. He was a visionary who understood the need for a collective voice for lawyers, founding the newspaper Black Coat, a first of its kind for the legal fraternity, and serving as the founder president of the Lahari Advocates Forum. a man of versatile passion from the nuances of Carnatic music to the precision of the snooker table and cricket pitch. He lived by the motto, never give up, never say die. Madam would be better to speak of that. It is in the spirit of this dynamism, his ability to adapt, to organize, and to lead that I present today's lecture. Just as P.G.C. grappled with the land reforms in 1970s, we must now grapple with the digital reforms of the 2020s. His legacy reminds us that the law is not a static monolith, but a living organism that must breathe in the air of its time. We find ourselves in an era where that air is thick with data, where the pulse of society beats in a binary, and where every concept of evidence has transmuted from the tangible to the ephemeral. I have been asked to speak today on the subject that strikes at the very heart of this, that is challenges in investigation and prosecution of cybercrimes in the era of digital evidence and artificial intelligence. This is not a mere topic of academic curiosity. It is the existential crisis of modern legal system which we face on everyday basis. Many of you have appeared before many of us about digital arrest, about freezing of accounts, lien on accounts. All these are relating to that. We are grappling with it. We are still trying to learn what to do and how to handle them. We are standing at the precipice where the traditional constructs of criminal jurisprudence, the physical crime scene, the eyewitness, the tangible weapon, are being rapidly supplanted by the invisible, the algorithmic, and the synthetic. As we transition from the Indian Penal Code 1860 to the Bharatiya Nyaya Sanhita BNS 2023, and from the Indian evidence to Bharatiya Sakshi Adhiniyam BSA 2023, we are still getting used to those names. We acknowledge a fundamental shift in the legislative landscape. Yet statutes are merely the skeleton of the law. Investigation and prosecution are its muscle and blood. Currently, that muscle is straining under the weight of petabytes. I don't know how many of you are aware, 1 petabyte is 1,000 terabytes. Our phone that we have is 256 megabytes. Our laptop is probably having 1 terabyte. 1,000 terabytes is 1 petabyte. 1 petabyte is 10,000 gigabytes, and 1 petabyte is 500 billion pages of text. And that petabyte is very small in the scheme of things, in the scheme of data. It is estimated that if we digitize our judicial records, it will turn into 25 petabytes. That is what we are planning to have as the cloud. So only the judicial data is 25 petabytes. Imagine what is there in the world, how many billions and billions of pages. The velocity of technological development has outpaced our procedural adaptation. We are fighting 5th generation digital warfare. This is supposed to be the 5th generation, with tools designed for the 19th century policing. The courtroom, once a sanctuary of establishing truth through oral testimony and physical exhibit, is now a theater where the liar's dividend, I'll come to that later, threatens to erode the very foundation of factual reality. In this discourse, I'll traverse the landscape of our new statutory framework, the procedural quagmires of the golden hour, the constitutional dilemmas posed by biometric compulsion, and the looming shadow of artificial intelligence in our courtrooms. We must ask ourselves, are we equipped to judge the machine? And more importantly, are we prepared to uphold the principle of natural justice, where the accuser is an algorithm and the witness is a stream of metadata? Chief Justice Vibhu Bakru sir did mention in a very succinct, very concise manner, he covered everything. I am only making my attempt to expand on that, but whatever he said is what I will be dealing with. There's a paradigm shift from IPC to BNS and now beyond. The enactment of BNS marked a decisive break from the colonial past, specifically in its recognition of cybercrime, not as a peripheral offense, but as a central pillar of organized criminality. For over a century, we relied on the IPC, a statute drafted with the telegraph, when the telegraph was the cutting edge of communication technology. So many things. And that was the cutting edge of technology. Today, we carry much more technology in our pocket than what was carried in a spaceship which went up to moon. Incidentally, the spaceship which went to moon had only 24 MB of RAM. In your pocket, you carry much more power than what that spaceship Apollo went to moon. For over a century, we relied on IPC, where telegraph was the cutting edge of technology. The BNS attempts to bridge this temporal chasm, but in doing so, it introduces new complexities that the judiciary and the prosecution and the advocates must navigate with extreme caution. Of course, defense lawyers will have a time because of the gaps which are there. The prosecution judges would have to suffer the brunt of it. There's a codification of petty organized crime and cyber fraud. I don't know how many of you are aware of Jamatra style, Jamatra being a place in Haryana from where they used to do the phone call scam. They used to call, pretend to be somebody, get a OTP, hack into your account. Jamatra is a series on Netflix, so from there it became famous as Jamatra style. So Jamatra style phishing scams. Phishing normally was phishing for fish, but now phishing is phishing for information and data. As Chief observed that the vocabulary is changing, the new vocabulary is entering into the court. This phishing, as what we thought as phishing, is something else which is there, and when we speak of it in court, it could be something else. So these are things that the younger generation more particularly will have to get aware of. Were they, these Jamatra style phishing scams, were they cheating under 420 of the IPC, as it then stood, or were they something more insidious? The sheer volume of these crimes, often committed by loose confederation of individuals operating from remote locations, defied traditional categorizations. Hence, BNS introduced Section 112, a provision that specifically targets petty organized crime. The words used are petty and organized crime. When you say organized, you'll normally think of big crimes, but this is petty organized crimes. There is a jurisprudential innovation of significant import designed to address the reality of modern distributed criminality. We have distributed ledger, distributed servers, now we have distributed criminality which comes in. Section 112 criminalizes offenses such as theft, snatching, cheating, unauthorized sale of tickets, unauthorized betting or gambling, and the sale of public examination question paper when committed by a person who is a member of a group or a gang. We have digital gambling, which again, there are so many matters which have come up. We have tickets which are being sold, Ponzi schemes, people buy it. We have question papers to examinations are being sold. That is why probably this 112 came about. The critical distinction here is the organizational element. A single act of phishing might be considered a minor offense if viewed in isolation. But when performed by a syndicate, it becomes a threat to public order and economic stability. Imagine UPSC examination papers being sold on WhatsApp, Telegram. Imagine class 10, class 12 being sold by different people acting in concert. What would be the status? Because today, technology, though an enabler and a good aspect, it could also be relating to bad aspects. Today, unfortunately, I am speaking of the bad aspects. Normally, I speak of the good aspects of technology, but that is what it is since I was given this topic. The critical distinction is the single act of phishing. It becomes a threat to public order and economic stability. The punishment prescribed, imprisonment of not less than 1 year, extending to 7 years, reflects the legislature's intent to treat these digital gangs with severity. Notably, these offenses are cognizable, non-bailable, and may be subjected to summary trials under specific BNSS provisions, imposing strict and swift procedural limits on the accused. However, the challenge for the prosecution lies in proving the membership of the group. In a physical world, a gang is a hideout, a territory, a hierarchy. But what do we do with this membership of a gang in the cloud? In the digital realm, gangs are not geographically co-located. They are loosely coupled nodes in a dark web network, often unknown to one another, connected only by an IP address or a telegram handle. How does the investigating officer prove membership of a group that exists only in a cloud? Section 112 defines the offense as being committed by a member of a group or gang, either singly or jointly. This phrasing places a heavy burden on digital attribution. To sustain a conviction under 112 for cyber fraud committed by a gang, the prosecution must link the individual node, the accused, to a larger network, the gang, through robust digital evidence, server logs, communication metadata, and financial trials. If this link is weak, the charge collapses into a simple individual offense, defeating the very purposes of this specialized provision. So it becomes very important for us lawyers to tomorrow's practice, to gear up to this kind of practice, to know about this, to even, these words are so out of our context, out of our human communication metadata, financial trails. These are not words that we speak normally, so we need to get used to them. Furthermore, the scope of Section 112 includes unauthorized betting or gambling and selling of public examination question papers. These are activities that have moved almost entirely online. The leakage of examination papers via WhatsApp groups or the running of illegal betting apps were quintessential examples of petty organized crime in the digital age. By grouping these diverse offenses under one umbrella, the BNS acknowledges that the method of organization is the common thread, yet the judiciary and lawyers must be vigilant. The term petty must not be misused, mislead us into complacency. These crimes, often involving small individual sums, aggregate to massive economic losses and erode public trust in systems like examination and banking. Little drops of water make a mighty ocean. So 100 rupees into 140 billion people, what would it be? The more complex and potentially religious challenges arises with Section 111 of the BNS, which introduces organized crime into the General Penal Code for the first time. This section defines organized crime to include cyber crimes, economic offenses, land grabbing, and trafficking when committed by a syndicate. This creates a legislative tug-of-war over special state enactments. Mainly, the example, though we have the KCOCA, Maharashtra MCOCA is the one which is more stringent, so I'll give the example of MCOCA, and the GCT COCA, Gujarat Control of Terrorism and Organized Crime Act. Notably, our court in Avinash versus State of Karnataka has cautioned that courts should be meticulous in granting investigating officer permission to invoke Section 111 of the BNS, underlining the sensitive nature of this provision. The interplay between Section 111 of the BNS and acts like MCOCA is fraught with prosecutorial dilemmas. MCOCA was enacted to address the specific menace posed by underworld syndicates in Maharashtra, and it contained draconian provisions that depart from the general principles of criminal law. Most notably is the admissibility of confessions made to a police officer of the rank of Superintendent of Police or above. Under MCOCA, such confessions are admissible evidence, a stark departure from Section 25 and 26 of the Indian Evidence Act, now 23.1 and 23.2 of the BSA, which render police confessions inadmissible. Section 111 of the BNS, while broadly defining organized crime to include cyber crimes, does not explicitly provide for the admissibility of police confession. This leads to a significant disparity. If a cyber syndicate operating in Mumbai, or even if one of them is operating from Mumbai, is charged with MCOCA, their confession to a Superintendent of Police is evidence, but not in Karnataka. Suppose the same syndicate is charged under Section 111 of BNS, perhaps because the IO chooses the central statute. In that case, they enjoy the full protection of the BSA regarding the admissibility of police confession. We risk creating a two-tiered system of justice for identical crimes based solely on the prosecution's geography or the arbitrary choice by the investigating agency. This becomes more peculiar because this crime is not geographically located. It could be anywhere. So any of the laws could be made applicable. The definition of organized crime in Section 111 is expansive. It includes economic offenses which are defined to include criminal breach of trust, forgery, financial scams, running Ponzi schemes, and mass marketing fraud. This breadth is necessary to cover the gamut of modern financial crimes, but it also introduces vagueness. The term cybercrime is listed as a category of organized crime, but unlike MCOCA, which requires the history of charge sheet to invoke the Act, the BNS definition relies on the nature of continuing unlawful activity. The definition of continuing unlawful activity in the BNS is crucial. It requires that more than one charge sheet has been filed before a competent court within the preceding period of 10 years, and that court has taken cognizance of such offense. This 10-year window creates a retrospective vulnerability because BNS has not been made prospective. Even the past could also be taken into account. It allows law enforcement to dredge up past conduct that may have been prosecuted as simple cheating or theft at the time, and use it as a predicate to charge an individual with organized crime today. This raises serious concerns about the precarious nature of this section and its potential for misuse. An individual who committed 2 minor cyber offenses 7 years ago could now find themselves labeled as organized criminal under Section 111. Of course, it is left for the lawyers to argue and for decisions to be rendered in that regard. It is important for the reason that he could face a minimum of 5 years and up to life imprisonment, and if death results, or even the death penalty in extreme cases. The introduction of economic offenses and cyber crimes into Section 111 also raises questions about the hierarchy of statutes. If a specialized act exists for money laundering, PMLA, or IT offenses, IT Act, does 111 BNS override them? The maxim generalia specialibus non derogant general laws do not derogate from special laws, would suggest that IT Act or PMLA should prevail. However, BNS is a later enactment, and Section 111 is a specific provision within a general code. This legislative overlap will undoubtedly be the subject of extensive litigation by Mr. Bala and several others on this aspect. We must also consider the punishment structure. 111.2 prescribes that if the offense results in the death of any person, the punishment is death or imprisonment for life and fine or not less than 10 lakhs. In any other case, it is imprisonment for not less than 5 years, extending to life. This appears to be a severe regime, but is it? When applied to cyber crimes which traditionally do not involve physical violence, the sentencing guidelines must be interpreted with proportionality. But can a ransomware attack on a hospital that causes a system failure and indirectly leads to a patient's death be prosecuted under Section 111(2)(a) as an organized crime resulting in death, attracting death penalty? Could it also be extended to autonomous vehicles? If an accident happens using an autonomous vehicle, could it be organized one? Because if 10 vehicles of any particular brand were to result in a particular accident and death causes, could the management of that company be prosecuted under this provision? These are issues which will be coming up now. The transition from the IEA to the BSA was intended to streamline the admissibility of electronic records. However, recent judicial pronouncements indicate that the judiciary will not accept digital evidence without strict adherence to certification protocol, as it ought to be. The digital record is fragile. It can be altered without a trace, corrupted by a surge, or lost to a magnet. Just keep a magnet, the whole data is gone. Therefore, the law demands a certificate of authenticity, a seal of integrity. The BSA now explicitly mandates the recording of the hash value that the Honorable Chief mentioned of the electronic evidence during the submission of the certificate to ensure its integrity. For those of you who may not be aware, hash value is SH256, which will be a system-generated code of the data at that particular point of time. If that data changes, the hash value applies to a clear categorical statement that this data is different from what was produced. The recent landmark judgment of the Kerala High Court in Alucas jewelry was anil. It was not about jewelry, it was about specific performance. This judgment serves as a critical reminder that the era of casual submission of digital prints is over. It reinforces the rigorous changes or this is the law today. The implications for cybercrime prosecution are profound. In many cybercrime cases, the primary evidence consists of WhatsApp chats. All of you have WhatsApps. Most prosecutions. Surprised, not surprised? Emails, server logs, and call detail records. The certifying authority, the person in charge of the computer system or the expert, is often a third-party intermediary. Google, Meta, X, Telegram, or a nodal officer of a telecom company. If the prosecution fails to obtain the certificates contemporaneously with a seizure or production of the record, the evidence is vulnerable. The Alucas jewelry doctrine essentially states process is as important as proof. A piece of evidence that proves guilt beyond reasonable doubt is worthless if it enters the courtroom without the passport of Section 65 certificate. So please be careful. This creates a practical nightmare for IOs. Obtaining a certificate from a US-based tech giant like Meta or Google can take months or years due to the cumbersome Mutual Legal Assistance Treaty, MLAT, process. By the time the certificate arrives, the trial may have progressed or the expert who signed it may have left the company, making the cross-examination impossible. The judiciary must grapple with this, lawyers must grapple with this. Do we sacrifice substantive justice at the altar of procedural rigidity, or do we find a way to expedite and simplify the certification process without compromising integrity? Of course, this will require legislative intervention. The golden hour and the volatility of evidence. In the realm of cybercrime, we speak of the golden hour. Normally in medicine, we speak of golden hour after the heart attack. Within 1 hour, he has to be in the hospital. There's a golden hour for cybercrime. Imagine the correlation and how the dots are connected. In the realm of cybercrime, we speak of the golden hour, the critical window immediately following the detection of a crime. Unlike a physical crime scene where a fingerprint might persist for days, a digital crime scene is highly volatile. Data resides in random access memory, RAM, which is lost the moment a device is powered down, network connection is severed, temporary files are overwritten, and the digital trial goes cold. If there's a computer and it is switched on or switched off at the investigation, everything that is there in the RAM is gone. The last accessed file is gone. So it is that volatile. The training must be required. Statistics indicate that complaints lodged within the golden hour have significantly higher success rates in freezing funds. In one instance, they saved 22.21 lakhs for victims because the complaint was lodged within 1 hour. The Ministry of MSME and Delhi Police have recently emphasized this concept in the context of financial frauds, noting that the capability to freeze money trails evaporates within minutes as funds are moved through mule accounts and converted into cryptocurrency. However, the golden hour is often squandered due to jurisdictional confusion and lack of immediate technical intervention. A victim of phishing scam often runs from pillar to post, from the bank to the local police station to the cyber cell, losing precious time. By the time an FIR is registered and a formal request is sent to the bank or the payment gateway, the money has crossed several international borders and probably has gone around the world in 1 hour. So it's not around the world in 80 days. So if this particular thing becomes that important, thankfully now we have 1930 and EFIR, 0FIR, so it can be lodged immediately. And unfortunately, that also results in another second round of victimization, because the person who might have received some 10 rupees, his account could be frozen. So those issues will also have arisen. Crucially, the golden hour also applies to the preservation of evidence. This failure to act correctly in these first few minutes leads to the degradation of the hash value, the of the evidence. A hash value, example SHA 256, is a unique alphanumeric string generated by the data. Even the smallest alterations, changing one character in a text file or modifying a single pixel in a photograph, produces a different hash. This makes hashing a powerful and reliable method for proving that evidence has not been modified. If a police officer untrained in digital forensic seizes a laptop and turns it on to check the files without using a write blocker, the operating system automatically updates the metadata, last access date, registry entries, etc. This alteration changes the hash value of the drive. When the forensic expert later images the drive, the hash value will not match the hash value at the time of seizure. If one was even taken, many a time it is not even taken. In court, the defense counsel can successfully argue that the evidence presented is not the same as the evidence seized, claiming tampering and breaking the chain of custody. This contamination of the digital crime scene is irreversible. The lack of standard operating procedures and the unavailability of right blockers at the police station level are fatal flaws in our current investigative infrastructure. Then, as the Honorable Chief pointed out, shortage of examiners, forensic examination, and 79A. A structural bottleneck that threatens to choke the judicial process is the acute shortage of examiners of electronic evidence notified under Section 79A of the Section 79A, the central government notifies certain labs and experts as examiners of electronic evidence. Under the BSA Section 39, the opinion of such examiner is a relevant fact and is treated as expert opinion. The intent was to create a cadre of specialized experts whose certification would be the gold standard for digital evidence. However, the reality is stark. The number of notified labs is woefully inadequate for the volume of cyber crimes. Cyber crimes rose 31.2% in 2023. 31.2. No other crime has risen at that rate. As of recent notification, only a handful of labs, such as Forensic Science Laboratory in Delhi, Rohini, Cyber Forensic Laboratory under the Army, and the State FSL in Karnataka, have been notified. Considering that cybersecurity incidents in India rose 22.68 lakh in 2024, this capacity is not even a drop in the ocean. This backlog in labs like the Forensic Science Laboratory in Delhi alone can exceed 22,000 pending cases, with the Cyber Forensics Division being significantly strained. Expert report backlog of 6 months to a year or more, delaying investigation, prosecution, and justice for victims. The government has recognized this, approving the setting of 6 additional national cyber forensic laboratories and the expansion of the National Forensic Science Universities to address this. In fact, to various judgments of the Madhya Pradesh High Court, Justice Pathak has passed several judgments due to which forensic science universities and labs have been established. So probably the state will have to take note of these things. This scarcity creates a massive backlog. Investigating officers are forced to wait months, sometimes years, for a Section 79A report. In many cases, they bypass the 79A route and rely on certificates from private experts. Regular FSLs, which may not carry the same statutory weight under the new BSA regime because they are not notified. This vulnerability is exploited by the Defense Counsel, who challenge the admissibility of the expert opinion. By the time the report arrives, the accused may have secured bail on the ground of delay in filing the charge sheet, or the trial may have been delayed to the point where witnesses turn hostile or data retention periods of intermediaries expire. This infrastructure gap is primary contributor to the abysmal conviction rate in cybercrime, which stands at roughly 1.6% nationally and remains shockingly low even in tech hubs like Mumbai and Bangalore. We are effectively building a Ferrari engine, the BNS and BSA, and putting it in a bullock cart, the FSA infrastructure. The disparity between legislative ambition and the logistical reality is probably one of the single biggest hurdle to cyber justice today. Mandatory videography. Now we have body-worn cameras, dash cameras. The BNSS introduced a procedural revolution with Section 105, the mandatory videography of search and seizure. This provision aims to bring transparency to police operation, curbing the rampant practice of planting evidence and fabricating recovery memos. However, it introduces logistical and technological challenges of petabyte profiles. How much is 1 petabyte? Section 105 mandates that the process of conducting a search of a place or taking possession of any property shall be recorded through any audio, video, electronic means, preferably a mobile phone. But mobile phone, again, hash value will not be there. The recording must include the preparation of the list of items and signing of the list of witnesses. Crucially, the police officer shall forward such a recording without delay to the district magistrate, subdivisional magistrate, or judicial magistrate of the first class. While the intent is noble, the practical implementation is fraught with difficulties that the courts will soon have to adjudicate. Storage and management costs. Police departments are now generating massive amounts of video data. A high-definition video of 2-hour search can be several gigabytes. Multiplied by thousands of police stations, millions of cases, we are talking about petabytes, or now something called exabytes of data annually. There is no centralized, secure cloud infrastructure designed for this purpose. Who pays for the cloud storage? Is the data stored on the IO's personal Google Drive, or the physical hard drive at the police station, or some cloud service for the police department, and that be accessible to the courts? Data integrity and hash values. A video file on a mobile phone is readable. Deepfake technology simple video editing tools allow for the removal of frames or the alteration of audio, unless the recording device automatically generates the hash value of the video file at the source and it uploads it to a secure, immutable ledger like a blockchain. The authenticity of the search video itself becomes a subject of intense litigation. Critically, SOPs mandate that the hash value of the individual image video footage be mentioned in the Panchanama and the case diary to ensure compliance with BSA. The defense probably will argue this video is edited. Where is the raw footage? Where is the hash value of the original file? Scope of mandate. There is ambiguity regarding the scope of this mandate. Does it apply to the personal search of a suspect, body search, versus search of a place? Section 105 mentions place and property, but Section 49 does not explicitly mandate videography. This has led to a confusion among field officers. If a recovery of a weapon happens during a personal search, which was not videographed, but a subsequent seizure of the weapon is videographed, is the search valid? These are newer issues. The without delay clause. The requirement to forward the recording without delay to the magistrate is safeguard against post facto manipulation. The procedure suggests that the police officer is expected to send a video recording to the magistrate without delay but not later than 48 hours, along with a copy of the list of seized item. In the absence of secure digital portal for this transmission, the IO is forced to manage sensitive data physically, making the without delay clause a severe procedural trap for the prosecution. The constitutional battleground, biometrics and self-incrimination. Perhaps the most intellectually challenging issue facing the courts today is the application of Article 23 of the Constitution, the right against self-incrimination to modern biometric authentication. The question is simple yet profound. Can the state compel an accused to unlock their smartphone using their fingerprint or face or PIN, whichever you use? The password versus biometric dichotomy. Traditionally, law distinguished between testimonial evidence, communication of knowledge, and physical evidence, fingerprints, blood samples. In the seminal case of 9-judge bench in State of Bombay versus Kati Kalu Ogod, AR 1961 SC 1808, that is a judgment which probably the Supreme Court held that given a fingerprint is not being a witness, giving a fingerprint is not being a witness against oneself because it's a physical reality, not a mental disclosure. The fingerprint exists independently of the will of the accused. However, in the age of smartphones, the fingerprint or the face scan is not just a physical identifier, it's a key. It unlocks a repository of the mind, emails, chats, location, history, notes, financial data. It grants access to the digital soul of the person. That is the word I used in the judgment in Virendra Khanna as the digital soul a smartphone would be. When dealing with Virendra Khanna, I said, I've taken a view favoring the investigation. I've suggested that compelling an accused to unlock a phone even via password might be permissible as part of investigation, provided a warrant is issued by the concerned court, and while such a search is carried out, the right to privacy is to be complied with. The rationale was that the content of the phone is a document and the password is merely the key to access it. The accused is not testifying to the content, they are merely providing access like in any search. However, the Delhi High Court has taken another view in CBI versus Mahesh Kumar Sharma. A special CBI court held that compelling an accused to provide a password violates Article 23 because a password exists in the mind and requires a volitional act of memory and disclosure. However, it distinguished this from biometrics, suggesting that physical compulsion for biometric, forcing a finger onto sensors, might be permissible because it does not involve mental disclosure. What is the artificial distinction that we will bring about? All of you use Face ID on Apple, Face ID on a Samsung, or a fingerprint on it. Easy, but very easy to get over also. They just need to show it to you. There's no volition which is required. Show it to the face, it will open. And if it's a password, you need to actually give the password for it to open. The US shift. In the international trend, DC Circuit Court in the United States was Brown. The court held that compelling a biometric unlock is testimonial because it forces the accused to translate their biological features into a decryption command. By unlocking the phone, the accused is testifying, I have control over access to this phone, and the print of this specific finger is the password to this phone. The act of unlocking communicates knowledge of control and access, creating a link between the accused and the incriminating data. The interpretation which comes about with lawyers arguing, all the lawyers arguing which results in the expansion of law. All of you are aware of Selvi versus State of Karnataka, where mental privacy is part of Article 21 and Article 23. The court ruled against narco-analysis, brain mapping, and polygraph tests because they forcibly extract mental content. Critically, the protection under 23 applies not just during trial, but also to suspects and witnesses during investigation process. Now we come to artificial intelligence, deepfakes, and liar's dividend. We now enter the domain of the synthetic. The proliferation of generative adversarial network GANs has democratized the creation of hyper-realistic fake media. How many of you are aware of deepfakes? Raise your hands. Quite a bit. So you know what a deepfake is and how a deepfake could be created. They learn from each other until the fake is a GAN consists of two neural networks. A generator that creates fakes that we are aware of, and a discriminator that tries to detect. Now we have a situation where the generator and the discriminator are acting together in such a way that they learn from each other until the fake is indistinguishable from the real. So what we are, from our human eye, we are unable to detect it. So we are using a software to detect whether it's a deepfake. But that software which is detecting the deepfake makes the deepfake software learn how it is being detected, and it becomes even better so that it becomes indistinguishable. The technology poses two distinct threats: the weaponization of deepfakes against individuals attacking personality rights, which has come about now, and the weaponization of skepticism against truth, the liar's dividend. Protecting personality rights, Sunil Shetty and Anjana Om Kashyap's precedents, all of you must be aware of it. The judiciary has reasoned with alacrity to the commercial and reputational threat of AI. In recent Sunil Shetty's case, the court granted omnibus John Doe order restraining the use of the actor's voice, likeness, and image by AI for unauthorized commercial gain. The court recognized that personality rights include the right to be protected from digital cloning, and that the unauthorized use of AI-generated avatars constitute a violation of the actor's right to livelihood and privacy. The court's expansive order protects the actor's persona or any platform, including emerging technologies like the metaverse. Why was this required? Why did Sunil Shetty have to go to court to get this order? No actor, there is no singer, there is no musician. Imagine what will happen to actors if their likeness is used by AI. Imagine what will happen to lawyers if their likeness is used. Incidentally, there was a matter where a client appeared through a AI-generated avatar in a court, if we are aware of that. And that AI avatar was arguing as if it was a lawyer. But the AI avatar is so prehistoric right now that you can make out. But tomorrow, if you can make out that it is Mr. Prashant Chandra's face and he is arguing the matter in the VC, can you make out? In Anjana Om Kashyap, a permanent injunction against a YouTube channel using deepfake technology to impersonate the news anchor. The channel used AI to clone her voice and face, creating fake news clips that misled the public. The court noted that such channels capitalize on anchor's reputation to spread misinformation, lacking any editorial control, and that this constitutes a violation of the personality rights and the deception of the public. The judiciary emphasized that it cannot turn a blind eye to the unauthorized exploitation of celebrity personality rights in the age of AI. These judgments are crucial. There are, of course, many more. These judgments are crucial because they establish that technology-used AI does not absolve the perpetrator of liability under tort or intellectual property laws. The courts are asserting that the digital persona is an extension of the physical self and enjoys the same legal protection. However, enforcement does remain a challenge. A John Doe order against an anonymous Telegram channel operating from a server in a non-extradition treaty country is often a paper tiger. The anonymity of the internet and the ease of creating new accounts make this game of whack-a-mole. The liar dividend, the death of the objective truth. A far more insidious threat to the administration of justice is the concept known as liar's dividend. As the public, liar's dividend is incidentally a game which is played and now it is been used, like golden hour. As the public and the judiciary become aware of how easily video evidence can be faked, it becomes easier for a guilty party to dismiss genuine evidence as a deepfake. Imagine a trial where a prosecution presents a CCTV video of a murder or a sting operation recording a bribe. The defense counsel argues, Your Lordship, in 2025, generating a video of my client at this location took 5 minutes with an AI tool. This video is synthetic. This is a liar's dividend, the benefit that liars derive from general skepticism about the authenticity of the media. If this skepticism takes hold, the standard of proof of electronic evidence will rise to an impossible height. Every video, every audio recording will be challenged as a deepfake. The skepticism benefits the liar and harms the truth teller. To combat this, we must now rely solely on the eye test, which is now unreliable. We must demand rigorous technical verification. Cryptographic watermarking. Proof of origin embedded in the file at the time of creation. Ministry of Electronics and Information Technology, MeitY, has expressed interest in watermarking AI-based synthetic content. However, we must proceed with caution as research reveals the vulnerability of watermarking techniques through diffusion purification. Whatever watermark is there can always be. Algorithmic auditing. Expert testimony that analyzes the noise patterns, lighting inconsistencies, and pixel artifacts to distinguish real from synthetic. But again, as I said, the discriminator will teach the creator. Adverse inference. Courts must be careful not to allow a bald assertion of its deepfake to shift the burden of proof unless there is prima facie evidence of manipulation or a failure in the chain of custody. It's ironic that Bangalore, the Silicon Valley of India, is also the cybercrime capital of the country. In 2023, Bangalore accounted for over 50% of all cybercrimes reported in metro cities. The city reported 17,631 cases for far outstripping Hyderabad and Mumbai, yet the conviction rate in Karnataka is abysmal because of all the reasons that we mentioned. 0.1% conviction reality. The disconnect between the tech prowess of our cities and the tech incompetence of our prosecution is staggering. In Mumbai, RTI data suggests that between 21 and 25, out of thousands of cyber financial fraud cases, convictions were in single digits, effectively 0 to 0.1% success rates. In Kerala, despite high literacy digital awareness, the conviction rate of cybercrimes hovers around 1%. Nationally, the conviction rate is estimated to be around 1.6%. The failure is not legislative, it's structural and systematic. That is what we'll be grappling with, and how, like in 1973 it happened, this issue can come about in the legislation. Lack of specialized prosecutors. Our public prosecutors are trained in IPC and CRPC. They are brilliant at arguing murder trials and property dispute, but they are often ill-equipped to explain the mechanics of man-in-the-middle attack, ransom encryption, hash collision to any judge or for a judge to understand it. The legal system suffers from a critical shortage of trained forensic professionals and specialized prosecutors. The defense, funded by organized crime syndicate, hires the best tech-savvy lawyers, creating an asymmetry of arms. The paper directions, in fact, our court in New Space Research and Technology for the state of Karnataka has directed the state to set up cyber command centers and specialized wings to tackle cybercrime. Our court observed that an ordinary investigating officer is ill-equipped to decode the labyrinth of cybercrimes. However, the court also lamented that this direction often remain on paper without a cadre of police officers who are also computer scientists. We are fighting a losing battle. International cooperation vacuum. Cybercrime, as I said, is borderless. The perpetrator is in Nigeria, the server is in Russia, the victim is in India, and the money is in the bank in the Caribbean. India is yet to sign the UN Convention Against Cybercrime or the Budapest Convention. This isolationism hampers our ability to access data stored on servers in the US or Europe. The traditional mutual legal assistance treaty process is now buckling under the weight of demands for digital evidence. This is complicated by the US Cloud Act, which allows US providers to compel data disclosures regardless of where it is stored, and subsequent rulings of the EU. By then, when a server is in California, the MLAT process takes years. By then, the golden hour is distant memory. UN Convention, Hanoi Convention aims to streamline this, but our investigation relying on informal channels or slow diplomatic routes creates a problem. Algorithmic auditing, a new constitutional mandate. As we introduce AI into judiciary itself, our case management, SUAS, research support, case management, translation, SUAS, research support, Jana, Adalat, RV, and perhaps eventually for predictive policing or risk assessment, we must introduce the concept of algorithmic auditing. If an AI tool is used to identify a suspect from CCTV footage, facial recognition, or if an algorithm is used to determine the risk of flight for a bail application like COMPASS in the US, the defense must have the right to audit the algorithm. It is a black box because how the algorithm works is not known. The manner of working is made known. Research indicates that facial recognition algorithms exhibit higher false positive rates for women and individuals with darker skin tones. Is the training data representative of the Indian population? To deny the defense access to the black box that accuses them is a violation of principle of natural justice and Article 21. We cannot allow trade secrets or proprietary code to trump constitutional rights. We need a framework for algorithmic due process where the logic of the machine is transparent, explainable, and contestable. Courts must interpret Article 14 and 21 to prevent arbitrariness in this automated decision-making process, ensuring that the technology enhances rather than undermines constitutional guarantees of equal justice. MeitY has released guidelines for algorithmic auditing, encouraging voluntary measures such as transparency reports, bias assessment, and technical audits, but needs to be translated into judicial mandates. Just as we audit the accounts of a company, we must audit the algorithms of justice. In conclusion, the challenges we face are not merely technical, they are deeply jurisprudential. We cannot The BNS and BNSS have given us the tools defining organized crime, mandating videography, but they've also imposed heavy procedural burdens that our infrastructure is not yet ready to bear. The digital evidence landscape demands a shift from believing what we see to verifying the hash value and ensuring strict adherence to the Alucas jewelry certificate. AI revolution threatens to erode the granting a dividend to the liar and a penalty to the truthful. As judges and lawyers, we must remain the human in the loop. We cannot outsource our conscience to an algorithm, nor can we allow the dazzling speed of technology to outpace the deliberate pace of justice. We must interpret the strictness of the law with the protectiveness of the Constitution. We just celebrated our Constitution Day, so it is more than important. We must guard the right of the accused against self-incrimination in the digital age while empowering the investigator to act decisively in the golden hour. This is the golden balance that needs to be drawn. The torch of justice must now illuminate the dark web. It is a heavy burden, but one we must bear with technological literacy, constitutional fidelity, and unwavering commitment to the truth, however virtual it may be. Thank you for Lahari for having me here. You have been living up to the standards set by Caesar. All the best to you.
Thank you, sir, for the insightful, in-depth, engaging, interactive, and comprehensive treatise on the existential crisis, as your lordships put it, in the current legal landscape, demanding a shift from believing in what we see to verifying the hash value. If I can take the liberty, his lordships had actually began the lecture with drawing a parallel between P.G.C. CHENGAPPA's, how late Mr. P.G.C. CHENGAPPA grappled with the land reforms of 1970s, and drawing a parallel to that, to the present scenario, we must now grapple with the digital reforms of the 2020s. And again, in the same breath, if I may take the liberty, how Mr. CHENGAPPA's lecture was so impactful that the state government was compelled to incorporate its findings into amendments to the Act. In the same breath, your lordships, your lecture has been so impactful, and we hope that the respective governments incorporate your observations into amendments and also try to fortify the implementation by bringing in more Section 79A examiners. I don't want to get into trouble, but Section 79A examiners or many such implementation tactics. Thank you so much. As a token of our gratitude, I now request Mohammad Harun to hand over a memento to our guest of honor, Chief Justice of Karnataka High Court, Honorable Justice Vibhu Thakur. As a token of our gratitude, we request Mr. Justice Suraj Govindraj to kindly accept a memento from Lahari Advocates Forum and Madhavi, who introduced Justice Suraj Govindraj to do the honors. as we conclude this remarkable, one-of-a-kind lecture, it's also time to acknowledge the contributions of various individuals and entities who made this event happen. I now invite our Secretary, Ms. Sumana Baliga, Lahari Advocates Forum, to deliver the vote of thanks.
Honorable Chief Justice Vibhu, Honorable Justice Suraj Govindraj, respected members of the bench, bar, family of late P.G.C. CHENGAPPA, revered seniors, designated distinguished guests, dear colleagues and students. On behalf of Lahari Advocate Forum, it is my profound honor and privilege to extend heartfelt vote of thanks on this memorable occasion of 18th P.G.C. CHENGAPPA Memorial Lecture. At the outset, we express our deepest gratitude to Honorable Chief Justice for gracing this event as a guest of honor. Your presence has elevated the significance of this program and has inspired every member of the bar. We are truly thankful for your valuable. Our special thanks to Honorable Justice Suraj Govindraj for delivering a illuminating and thought-provoking lecture on subject of immense contemporary relevance, challenges in the investigation and prosecution of cyber crimes in an era of digital evidence and artificial intelligence. Your insights today have enriched our understanding and will undoubtedly guide the legal fraternity in navigating the evolving technological landscape. We take this opportunity to remember with reverence late Sri P.G.C. CHENGAPPA, whose vision, dedication and exemplary service to the profession continue to inspire Lahari Advocate Forum even today. This annual lecture is our humble tribute to his enduring legacy. I also extend our heartfelt gratitude to the family of late Sri CHENGAPPA for gracefully accepting our invitation and honoring this occasion with their presence. In particular, we express our sincere thanks to Srimati Sushila CHENGAPPA, the beloved wife of Sri P.G.C. CHENGAPPA, for joining us today and lending the strength, warmth to this memorial gathering. I sincerely thank all esteemed judges, senior advocates, officers of the court, faculty members, and students from various law colleges for your gracious presence. Your participation strengthens the academic spirit with which this program has concluded. My heartfelt appreciation goes to the President, Executive Committee members, organizing team, coordinators, volunteers, and every member of the Lahari Advocate Forum who worked tirelessly behind the scenes to make this event a resounding success. We also thank High Court administration, especially the High Court administration, the Registrar General, the Registrar Administration and Registrar Computers, security staff and technical team. We are thanking the members of the, we are extend the thankful, heartiest thanks to Mr. Prasanna for printing the speech booklet, and Mr. Naveen and his team for arranging the high tea. We further express our appreciation to the photography, videography team for their cooperation and invaluable support. Finally, to every attendee present here this evening, thank you for being part of this tradition and for contributing to the intellectual vibrancy of our forum. Thank you all.